As a human rights organisation, FLAC is committed to promoting justice for all, including members of society who are in prison. In this week's event, you will hear from an incredible lineup of speakers sharing their professional insights into the topic of prisoners' rights. Our first speaker is Ciara Kirrane, who has been a caseworker and family support officer with the ICPO for the past 5 years. The ICPO provides information and support to Irish prisoners overseas and their families, and engages in policy and advocacy work on issues affecting such persons. In this talk, she'll be discussing the work carried out by the ICPO, including the findings of a survey conducted last year of Irish people imprisoned overseas. Our second speaker is Dr. Mary Rogan, who is a barrister and associate professor at Trinity College Dublin. She is dedicating research to reform penal policy and policymaking process, and also has research interests in criminal justice policymaking and human rights and imprisonment. She has written books on prison law and prison policy, and is a former chairperson of the Irish Penal Reform Trust. In this talk, she'll be discussing the constitutional provision for the right protection of the person and how that implies in the context of imprisonment. We hope you enjoyed this event, and we'd like to sincerely thank all of our guests for participating.
Hi, my name is Ciara Kirrane. I'm a caseworker and family support officer with the Irish Council for Prisoners Overseas. I'll tell you a little bit about our organisation, how we were set up, and the work that we do, and I'll also try and outline some of the issues that affect the prisoners that we work with all around the world. So to start with, we were set up in 1985. At that time, the Troubles were obviously still ongoing in Northern Ireland, and there was a disproportionate number of Irish people being imprisoned in England. And the Irish Catholic bishops who founded our organisation identified a need, I suppose, to respond to those prisoners and to their families here in Ireland at that time. So that's how the organisation was set up, and that was our purpose, to respond to their needs. I suppose over time we've expanded and our reach has probably expanded, and we now work with over 1,000 clients in over 30 countries around the world. So the vast majority of those clients would still be in England, but we do have people all around the world. The type of support that we offer really depends on the person in prison, what they need, and where they are, because obviously how you support somebody varies quite a bit depending on their location. But in general, we would provide information and advice, and that could be about a range of issues. Could be around the conditions that they're existing in, maybe ill treatment, health, deportation, whether they're trying to transfer their sentence back to Ireland. So we'd provide advice and information about a range of different issues. We also liaise with other agencies, I suppose primarily with the Department of Foreign Affairs. We work quite closely with them to provide support to Irish people overseas. And we would also work with the likes of probation services in different countries, obviously the prison staff, and various other third parties like that. We provide prisoners then with, I suppose, as much sort of in-cell activities as we can. So we'd send newsletters on a regular basis. We'd send greetings cards at particular times of year, like Christmas, St. Patrick's Day. We have in-cell kind of packs that we send that have, history books, colouring books, different puzzles, different things to keep people occupied while they're spending quite a bit of time in their cell. Obviously a lot more as a result of COVID. We also, a huge number of our clients would be quite isolated, and so we have a pen friend scheme as well, where we have volunteer pen friends here in Ireland who would write to Irish people in prison around the world. We can provide support, small amounts of financial support to prisoners and their families, and we'd also assist with visits and things, kind of practical matters like that. So providing advice for families visiting prisons. Last year we provided, I suppose, in total there was over 10,000 emails, phone calls, and letters, with or on behalf of the clients that we work for. It can be very hard to sort of generalize about, prisoners' rights when we're working with such a broad across such a broad spectrum and number of countries, and obviously, depending on the country, the rights of prisoners would vary quite a lot. So I'm going to just talk a little bit about the different issues that we would see coming up in different parts of the world. And then I'll tell you a bit about a survey that we completed last year that does kind of help to, I suppose, generalize the picture a bit better. So I suppose, like I said before, the vast majority of our clients would be in the UK. And prior to lockdown and prior to COVID-19, the time spent in cell across England for sure was extensive. So prisoners were routinely spending 23 hours in their cell prior to COVID at all. And that's a result of, I suppose, difficulties within the prison system, resourcing, staffing. So for quite a number of years, we've seen that as a really big issue in England. And obviously the knock-on effects for prisoners' mental health and their well-being and their ability to take part in things like education and work. In England as well, what we would see is we work with quite a number of travellers, and there's certainly a disproportionate number of travellers within the English prison system. So that can be an issue, and obviously discrimination, both for travellers and for non-travellers, continues to be a problem, unfortunately. In places like the United States, what we see a lot of the time is it's the length of the sentences that people are serving that would be, the key issue affecting prisoners. The conditions can also be quite harsh in a number of US prisons. And I suppose deportation would come up as an issue quite a lot as well, because very often prisoners would be deported from the States, and sometimes that can be, a person who hasn't lived in Ireland for most of their adult life. They might have emigrated to the States, at a young age, and then after serving their prison sentence are automatically deported. So that can be a particular issue as well. That's something we see in Australia a lot as well, where, again, people emigrated as very young, often as babies, with their families, and then they can, end up serving a prison sentence and automatically then facing deportation, which is extremely harsh because they're coming back to a country that they haven't known or lived in, and usually don't have any family ties or friends here to support them when they return. So that would be an issue in both, the States and Australia. I suppose when it comes to Europe, a lot of the time, language barriers would be the issue there, because you're dealing with, very often people are dealing with a prison system and a legal system that isn't in their own language, and it can be very hard to negotiate that. So, where we can, we support prisoners with language packs and with dictionaries and anything we can, really, to support them in trying to, assist and develop their language capabilities. But it's still incredibly difficult to be negotiating a system when, English isn't the spoken language. In the rest of the world, so we would have very small numbers then dotted throughout the rest of the world, in Central and South America, across Africa, Asia, and the Middle East. Again, really the key concern there would be around conditions. So, the lack of food, lack of sanitation, having to often pay for things that, wouldn't normally need to be paid for in a prison system, let's say here. So it can be quite a strain on prisoners and their families. And yeah, where we can, we will provide, for those who are facing extreme sort of hardship, we provide grants to them on a regular basis, so that they at least have the means to maybe pay for, extra food, water, whatever it is that they need that isn't being routinely provided by the prison. So just while it isn't, the case that we can really generalize across, how our clients experience imprisonment, because their experience is so different. We did conduct a survey last year, late last year, and I suppose in that, even though I think it was over 70% of the respondents were based in the UK, we did have the rest came from all across the world. The findings, I think, would be reflective of how our clients experience imprisonment. Over 60% had mental health difficulties and struggled with their mental health, and that was really the key challenge for them. We also saw that over 50% identified loneliness and isolation and as one of their main difficulties in prison. Unfortunately, there was, I think, 55% said the length of time they were suspended in cell was a particular challenge for them. Now, obviously, this was conducted during COVID, so almost all prisons were on lockdown. But as mentioned earlier, that wouldn't have been, all that unusual prior to the onset of COVID-19 across some of the prison estate in the UK. We also unfortunately saw that 25% of prisoners identified discrimination as a particular challenge for them. So, obviously that continues to be an issue, and something that we work on where we can with embassies, with consulates, with the prison staff and through equality officers where they're available. Another interesting finding of that survey was the fact that over 70% of people were concerned about their family while they were in prison during COVID. So when we asked what impact has COVID had on you, the vast majority, and actually the largest majority, identified the impact as being the worry that they felt for their family members back home. So I think that really highlights, the key challenge being a prisoner overseas. Obviously when you're in prison, you're separated from those you love anyway. But when you're in prison overseas, that separation is all the harder because, the distance, the cost to families to visit their loved ones, sometimes the logistics just make it so difficult that, that families can't visit. Obviously if parents are in any, family members could be unwell, aging, potentially children might have special needs and might not be able to visit their parents overseas. All of those things are sort of, they're issues that prisoners would face in Ireland when their families are in Ireland, but it's exaggerated and probably all the more difficult when you have that distance between you and when you're potentially in Australia and hopping on a flight just isn't something that's possible on a regular basis. So for families, we do provide quite a lot of support. We work closely with families here in Ireland where they want support, and we would provide, I suppose, emotional support to them, but also practical assistance, as I mentioned earlier, around, if they do have the ability to visit, we would try and support them in any way we can with that. And I suppose it's really trying to help them navigate through a system that can be very, unfamiliar, isolating, and where there's a lot of stigma and shame, because often, families won't share the fact that they have a loved one in prison overseas. They won't share it with other family members or with their friends. It's something that they feel particularly, embarrassed about and find very difficult to share. So oftentimes we might be the only people they speak to about the fact that their loved one is overseas in prison. So, it can be extremely difficult for family members here, and we provide as much support as we can to them. So I think I'll wrap up on that note. I mean, I hope that's given a flavour of the work we do, and obviously it's hard to fit it all in a certain amount of time, but more than happy to address any questions or anything like that following this talk. And thanks for the opportunity to FLAC for inviting us to speak today.
My name is Mary Rogan, and I'm an associate professor in law at the School of Law, Trinity College Dublin. I'm also the principal investigator of a project funded by the European Research Council called Prisons, the Rule of Law, Accountability and Rights, which examines prison oversight in the form of inspection and monitoring, complaints mechanisms for people in prison, and review by the courts. In the PRILA project, we're exploring the legal frameworks for these types of prison oversight. We're also interested in the experience of people in prison, of prison staff, and of staff of oversight bodies of this kind of scrutiny. And we're also exploring the types of structures which exist for prison oversight within the European Union. In this short video, I'd like to explore the concept of the right of protection of the person in the Irish Constitution as applicable in the setting of imprisonment. And over the last couple of years, we've seen some very interesting developments in this area through the growth of prison litigation in Ireland. For many, many years, prison law was very much a niche discipline within Irish legal scholarship and within practice. And it's only really in the last 5 to 7 years that we're seeing a growth both in specialism and also in the numbers of cases which are coming before the superior courts concerning aspects of prison life, particularly prison conditions or decisions made concerning the use of imprisonment, so specifically around segregation or the use of isolation. And I think it's really valuable that the superior courts are getting more opportunities to explore how the Constitution in particular applies within the walls of prison. And it's fair to say that a core principle emerging from these cases is that the Constitution very much applies within the context of imprisonment, and to hold otherwise would really be a sad reflection on our society. Now, that being said, there are of course ways in which the constitutional protections within prison could be improved from a structural perspective regarding how the law is applied, but also very much from a practical perspective in how we fulfill the obligations under the Constitution to people within prison. So I'd like to explore really 3 cases in which the protection of the person has been used as a core principle or right arising out of poor prison conditions. And the cases I would like to explore briefly are Kinsella and the Governor of Mountjoy Prison, Connolly and the Governor of Wheatfield Prison, and Simpson and the Governor of Mountjoy Prison. These cases, to me, the legal principles are obviously hugely important and interesting arising out of them, but they're also very important cultural artifacts because they tell us an awful lot about how we use imprisonment in Ireland and the nature of the conditions they're in. And I think future generations will use these judgments not only for their legal principles, but also as documents or evidence of the types of conditions which existed in Irish prisons in what we consider to be very much modern times. And I think there are many ways in which these judgments are quite sad, actually. So the first case, Kinsella and the Governor of Mountjoy Prison, the applicant, Mr. Kinsella, was on protection, which is a colloquial term used in Ireland for segregation or isolation. It's where a person is placed away from the general prison population, isolated from the general prison population because it's believed as a threat to them, of harm to them. And it can be something which people in prison actually request for themselves, that they, even though the consequences are very long periods of lockup in their cell, they may view this as preferable to the threat which might emerge if they're allowed to circulate with other prisoners. So in this case, the applicant was in that position. The applicant was on protection and was placed in an observation cell in the basement of the prison. And the cell was approximately 3 metres by 3 metres. It was entirely padded and contained nothing other than a mattress. There was a small window providing some natural light. That window had a shutter, but there was a dispute in evidence as to whether the shutter was actually working. The applicant further maintained that he was provided with no reading material and he had no access to a radio or television. And Mr. Justice Hogan, then in the High Court, held that these conditions had breached the applicant's right to bodily integrity, finding that the detention had amounted to a form of sensory deprivation, noting that the judge was using this term advisedly as they were still very far removed from those found in the ECHR case of Ireland and the UK. But in the view of the court, the protection afforded by Article 43.2 extended to the integrity of the human mind and the personality, and that prolonged detention in these kinds of circumstances gave rise to a risk of psychiatric disturbance. This was a really important judgment as it laid the foundations for developments in concerning the right to protection of the person, and I suppose the general protections which are found in Article 43.2 concerning how prison is used and prison condition cases specifically. This was a really important judgment and a strong foundation which was used to elaborate on the protections which a person can expect to receive under Article 43.2 of the Constitution when in the prison context. The decision in the case of Connolly and Governor of Wheatfield Prison concerned the compatibility of the detention of a prisoner for 23 hours a day in his cell with this same article of the Constitution. The person had requested to move to single cell occupancy, having been the subject of a rape by a cellmate in a previous prison, and was moved to single cell occupancy. And he was fearful of homophobic victimisation in the prison. The court decided that these conditions were very, very different to those of Mr. Kinsella, in that he had meals in his cell, but his cell had a bed, a counterplace for storing clothes, a television, a toilet and a sink, and he was able to go outside of his cell for 1 hour a day and had ready access to reading material. These conditions were viewed as being significantly better than those which Mr. Kinsella was enduring. However, the length of time was quite different. As the judge, again, Judge Hogan in the High Court held, Mr. Connolly was likely to be detained in these circumstances, which he described as approaching solitary confinement for several months. Now, while these conditions weren't perfect, they were immeasurably better than those found in Kinsella. And again, in an important statement of principle, Judge Hogan considered that every detained person must be permitted some meaningful interaction with the human faculties of sight, sound and speech, as such an interaction is vital if the integrity of the human personality is to be maintained. And this was facilitated through access to reading material, through the use of the television. And it was very important in the case that the individual had actually asked to be placed in this form of isolation. However, the long locking up of prisoners under these circumstances for very long periods of time, which the court would measure in terms of extended periods of months, must be regarded, the court held, as an exceptional measure which might, in some instances at least, compromise the substance of the detainee's right to the protection of the person and the safeguarding of human dignity. And indefinite detention in such circumstances would certainly breach 43.3. The Connolly decision also contains one of the most eloquent statements concerning the rights of prisoners in the modern era, where Judge Hogan drew on the preamble to the Constitution, which seeks to ensure that the dignity and freedom of the individual may be assured, in order to ground his finding that, quote, the obligation to treat with dignity appropriate to the human condition is not dispensed with simply because those who claim that their essence of their human dignity has been compromised by prisoners. And Judge Hogan went on to say, in a further, if I may say, beautiful statement of the application of constitutional principles, that while prisoners in the position of Mr. Connolly have lost their freedom following a trial and sentence in due course of law, they are still entitled to be treated by the state in a manner by which their essential dignity as human beings may be assured, while due and realistic recognition must be accorded to the judicial branch the difficulties inherent in the running of a complex prison system and the detention of individuals, many of whom are difficult and even dangerous. For its part, the judicial branch must nevertheless exercise a supervisory function to ensure that the essence of these core constitutional values and rights, the dignity of the individual and the protection of the person, are not compromised. And the judge went on to say, for even though prisoners may have strayed from the path of righteousness and even severely and wantonly injured other persons, the protection of the dignity of all is still vital. This is because the Constitution commits the state to the protection of these standards, since it presupposes the existence of a civilised and humane society committed to democracy and the rule of law and the safeguarding of fundamental rights. And I've paraphrased a little bit there, but that's the essential drive of this very important statement of principle. We see a return and a very important elaboration of the protection of the person in the prison context in the more recent decision of Simpson and the Governor of Mountjoy Prison, which concerned, amongst other things, not just slopping out, but slopping out was a primary focus of that decision. Now, in the Supreme Court, Mr. Justice McManaman noted a strong connection between the constitutional right to privacy and the value of dignity, and stated that the words person and personal not only carry with them the ideas of individual privacy and dignity, but also the respect due to each individual by virtue of his or her status as a human being. And the analysis which Judge McManaman undertook in the case of Simpson provided a lot of clarity on the question of what claims people can make in prison conditions cases, and also helped practitioners and scholars to understand the contours of this really important protection of the person in the prison setting. And Judge McManaman held that describing the right infringed in the circumstances of the Simpson case as simply that of privacy was a form of shorthand, but that it was more than this, stating that in truth what is at issue in this case lies at a point where the right to privacy and the value of dignity could be seen as lying at the base points of a pyramid which has as its apex the respect due to any person. These are the attributes of personhood, and along with other values such as autonomy, are aspects of the protection of the person afforded by Article 43. And I think this protection of the person is something that we should very much uphold and strive to uphold in the practical reality of the prison context. And it's very useful and uplifting to see the course using the protection of the person in this setting.